LLC, the original defendant in this case. I am not an employee of the city. I'm an independent attorney that's been selected by the city council to hear cases like this. The only thing I know about the case is what I did in 2022, and then the paperwork that's been submitted to me this afternoon. Our process usually is to let the city go first, and then there's a response from the owners. What I'd like to do is have everyone identify themselves first. This is the only case, by the way, that's on our agenda today, so we'll make sure we give it all the attention it needs. I'll start. Ms. Stuparich is the city attorney. Go ahead.
Thank you. My name is Nancy Stuparich, and I have the honor of serving as the city attorney. I am an attorney with the Vos Law Firm.
I'm Pete Dewar, the code enforcement manager for the city of St. Pete Beach.
And then anyone from your team who will be testifying, or just you? Okay. All right. And I know we have some other city employees who are just here to observe then. Is that correct? All right.
Your Honor, we will have someone from budget here and also from the building department.
They'll be coming later?
Yes.
Okay. All right. 4 gentlemen in the front row, if you could identify yourselves, because I'm assuming that, is District Holdings here, or you are all?
District Holdings is here. I'm Adam Kestenbaum for District Holdings.
Okay. You were involved, at least your name was involved at the original hearing, going back.
My name was involved in the original hearing.
Right.
I will tell you, I don't believe I ever received notice of it.
Okay. And, sir?
Owner Ben Abraham, I'm a co-owner, KO Capital Partners Florida.
Okay. Sir?
Kiefer Dayan, the second co-owner of
Okay.
Capital Partners Florida.
My name is Anthony Pavic, and I'm the GC of the project.
Pavic, P-A-V-I-C-H?
Edward Kilo.
I'm sorry.
E-K. P-A-V-E-K.
E-K.
Yes, sir.
And you're the GC?
Yes, sir.
Okay, excellent. All right, usually we start with the city. Usually that's a new case coming in, but since this has some history, I'll recite a set of facts that I believe are undisputed, and then I'll let each side tell me whether I've assessed the situation accurately or not. The case started in 2021. The allegation was that the then owner, started either repairs or redevelopment without permits, and that the property was in substandard condition. That was in 2021. On February 14th, 2022, I entered an order imposing a fine of $250 a day, retroactive to August 2nd, 2021. Mr. Matt Johnson, who was the property manager, appeared at that hearing. The city put on evidence, and that was the order I entered on that day. On March 9th, 2022, the city recorded a lien against the property with the Pinellas County Clerk, and basically it was the order that I had signed on February 14th. On April 8th, it appears the property was sold, April 8th, 2022, property was sold to KAO, Capital Partners. Assume that's who the two of you, Mr. Abraham, right?
Ben Abraham, yeah,
okay, and Mr. Dayan?
Yes, sir.
Okay, and that was April 8th, 2022. 5 days later, at a hearing in this room, I was asked to enter a second order that I took to be as an agreed order with the then owner, well, at that point, the former owners, indicating that there'd be 90 days to rehab the property, starting from April 13th. That $86,500 was going to be deposited by the original owner with a title company, and that was the estimated amount of the fines that would have accrued through that 90-day period. The fines were going to run until the property was brought into full compliance, and that I, as a special magistrate, would have continuing jurisdiction to enforce the order. That's the order that I signed on April 13, 2022. This year, looks like the case restarted June 18th. The second order I signed in April of 22 was recorded with the Pinellas County Clerk. On June 19th, Ms. Stuparich, in her capacity as city attorney, sent a demand letter to the title company asking for the release of the $86,500. 4 days later, I was asked to issue a subpoena to West Chase Title, asking them to provide documents to the city showing what was actually in the escrow and the documents that dealt with the $86,500 that was deposited in escrow. On June 26th, the property was posted with notice to the owners, and it included both KAO Capital Partners and also the former owner, District Holdings Florida LLC, and the registered agents. And then there was written notice sent the same day to all the parties, KAO Capital Partners and District Holdings. That was June 26th, informing them of today's hearing. Today, what's on the agenda is a status report from the city, and then Part B of the review today is whether I would enter an order authorizing the city to foreclose on its code enforcement lien that was recorded in 2022. That's what I believe is before me today. There is a state statute, Florida state statute, and the city code that provides that the special magistrate may authorize the city attorney to foreclose on a lien after 3 months of the lien being recorded. So that's what brings us to today. Turn it over to Ms. Stuprich if you have anything to add or to correct. And
Thank you, Your Honor.
I think Mr. Dewar had an opportunity to hear my recitation, what I thought.
Well, I think he came in at the right moment. The city's position, we have, I believe, we've extended notice of our concerns today, of today's hearing to everyone that we felt was a part of this transaction and code violation. So the city's position, and I will offer the testimony of our code enforcement manager as well as our building official regarding the status of the property. It is my understanding that the property is currently not in compliance with the code, that it remains in violation of the sections that were cited in your prior order. Also, that there has been no ability to bring it back into compliance, and therefore there's been no release of the escrowed money to the city to basically pay down the amount of the lien. We'll also be presenting an affidavit from, or a representative from our finance department who will now give you the current amount of the lien that is due and owing the city. At the time of these prior orders in 2022, it was anticipated close to their day of closing, the amount of the lien was $64,000, with the anticipation that the property would be brought into compliance, and therefore then subsequently a request could be made for a lien reduction, which of course did not happen. The amount of the fine has continued to accrue. And as I said, we'll have the exact amount for you. That is what we know regarding the status. Some of those facts will repeat itself when we go into a discussion regarding the authorization to foreclose. So at this point, I would defer to our code enforcement manager to discuss the status of the property as far as compliance, and I believe we have a representative from our building department here as well.
Yes, our building official, Luke Curtis, is in lieu of Luke Curtis, our building official. Joe Boland will tell us the update on the status of the permit against the existing owner. This case does not just include the existing owner, but the previous owner, and the agreement was that the city entered into some sort of a agreement so that the transaction, the sales transaction that occurred, could have happened as opposed to the previous owner having to pay the full amount of the fines that I think has accrued to over $300,000. And that's what this is, that there was funds held in an escrow account to be released to the city if the property was not compliant within 3 months of the order that you executed.
Ms. Stuprich, did you get a response then from West Chase on the subpoena that you issued?
We did not. So again, we were trying very hard to find some documentation regarding the settlement that was represented to the former city attorney that sat, Mr. McConnell. So we did not find a copy of a settlement agreement nor a copy of an escrow agreement. We also thought that perhaps there might be reference to the escrowed funds on a closing statement or some other type of documentation. So we did request that a subpoena be issued to West Chase, and that followed our demand letter. And to date, we have not received any information from them.
Okay. All right. And you wanted me to hear testimony then from your, from city officials or city employees?
From our building official, if you could provide an update on, she's not here? Okay, how about finance?
Joe Boland, who is going to be speaking on behalf of Luke, has access to the permit information and the current status.
Okay, is she here?
Yes.
Okay, yes.
Boland.
If you can come to the stand, and I'm
All right,
assuming.
you know, before we do that, I kind of did what I would characterize as an opening statement here. So what I'd like to do is just turn to the owners and former owner, and if somebody from the group wants to make a brief opening statement, just to give me your perspective on where we are, if you want to. You don't have to, but I would like to hear from you now, if that's possible.
Yeah,
Come on up. Yeah. So we're not going to, normally, if you're going to give testimony, you have to be sworn in. At this point, because we are just dealing with opening statements, I just want to hear what your position is, and then we're going to go through a formal process if there's a need to do so. Go ahead, sir. And you are Mr. Kestenbaum.
Kestenbaum, yes.
Right.
Yeah.
Go ahead.
So I don't have remarks prepared, so I'll go off the cuff. Some of the things that were said make sense to me. I think I understand them, and others that I'm hearing for the first time. So just to start from the beginning, my company acquired the property in 2020 with intent to renovate the property and restabilize it in compliance with all city requirements. I hired a company that I am familiar with. This is the first property I had ever bought in St. Pete Beach. I owned a few properties in Sarasota. I had a good relationship with the company down there that I engaged to manage the renovations and the lease up and stabilization of the property. And I have a full-time job. I live in Washington, D.C. I am not local to the area. I generally trusted them and relied on them to manage all aspects of the property, of the renovations, repairs, stabilization, and just to put another point on it, when I bought the property, I closed on it in, I think it was February of 2020, just before the COVID pandemic hit. When I acquired the property, it was fully leased. Once COVID hit, I was unable to collect a single penny in rent. Every single one of the 14 units. And they all knew each other, I think, and they just decided they were not going to pay rent. So I funded, everything out of my pocket. We did the best we could to bring the property into compliance. I don't have the figures in front of me. I think I spent somewhere between $300,000 and $400,000 on renovations. The company that I engaged, and this is Mr. Matt Johnston, works for that company. I don't know what permits would have been required or what he did or didn't do. The reports that I got, throughout, call it 2020 and 2021, were that he was doing everything that he could do to bring the property into compliance. It was made difficult by the fact that the tenants who were there at the time, essentially refused to vacate the property. And it became a difficult situation. I continued to fund, the property, paid all the taxes, paid all the repair costs. until simply it became too painful for me to do it anymore, to be honest. And I'm a full-time practicing attorney in Washington, D.C., although I will tell you this is the first time I've set foot in a courtroom in 20 years. Simply not what I do. And I just decided I couldn't do it anymore and decided to sell the property. When I decided to sell the property, I think was the first time that I had learned of code compliance issues or anything relating to a lien on the property. It quickly became pretty clear to me that it was not going to be possible to bring the property into compliance on my own. I just don't have the skills to do it. And I no longer really fully was able to trust or rely on the company that I'd engaged. I didn't really have enough contacts locally to be able to hire someone else, so I decided to sell the property. Engaged a broker, and the broker marketed the property and eventually struck a deal to sell the property to these gentlemen here and their company. I knew that there were discussions between my broker and representatives from the city about the lien. My intention was to sell the property subject to the code compliance lien. To my knowledge, there's nothing in the Florida statutes or city ordinances that prohibits a property from being sold subject to a lien of that type. I don't know if that's true or not, but that's my general understanding. I'm not a real estate lawyer. That was my intent, and that's what we ultimately agreed to do. KAO Capital Florida and District Holdings Florida agreed that the property would be sold subject to the lien, with an expectation that that these gentlemen would bring the property into full compliance. The notion of a settlement with the city is, well, certainly something that I have heard over the last, call it 2 years, maybe 3 years, that there was a settlement entered into in connection with that sale. I did not sign a settlement agreement. My intention was to sell the property subject to the code compliance lien. As part of the transaction between my company and these gentlemen's company, there was an escrow agreement for, and I didn't know the number off the top of my head, I think you said $86,500. For that amount of funds be deducted from the purchase price of the property, put into escrow, and held in escrow by the title company. The expectation at that time was that the escrow would be held, the escrowed funds would be held for something like 90 days. To be honest, I'll be fully transparent with you. My expectation was that there was zero chance that the repairs could actually be done in 90 days. But I was the seller in the transaction, and that's what we all agreed to. The escrow did not have a limited period of time on it. There is an escrow agreement, and I'm happy to provide that escrow agreement. I don't have a written copy in front of me, but I have it on my computer. If you want me to print it out for you, I'm happy to even do that right now. I've got the computer in my car. The gist of the escrow agreement, though, is that once the repairs had been done, that the property were brought back into compliance with all city requirements, that the two of us, the buyers and the sellers, would jointly, I'm not sure what the technical term is, but do some kind of a request for a fine reduction, which I was told is relatively routine, with the hope that, and I sort of recognize that we're kind of at the mercy of the city, with respect to the reduction in the fine. But we were expecting to do the fine reduction request, and essentially, throw ourselves at the mercy of the city for that to be reduced, and for some of those escrowed funds, depending on what the ultimate reduction in fine was, be released to the city, based on our written instructions, and then the rest of the funds be released to myself and to them. And there's a relatively complicated provision in that agreement as to how any remaining funds would be split between them and me. The city is not a party to that escrow agreement. To my knowledge, the city never requested to be a party to that escrow agreement. I think that's pretty much everything. Beyond that, since then, these gentlemen can tell you, their journey in terms of trying to bring the property into compliance. My understanding is they were pretty close until the hurricanes of 2024 hit, and that was a major setback for them. I think that's all I had to say. I'm happy to answer any questions that folks have.
All right.
I would also say I know there was a hearing in 2022. Now I know that there was. The first time I learned of that hearing was when I received the notice for this hearing. I don't know what happened. It was a little bit surprising to me because that hearing was only a couple of days after we closed on the sale. And so I was sort of surprised that nobody brought that up to me. I'm pretty sure no one brought it up to these gentlemen either. I do know that I was never served notice of that hearing, and to the best of my knowledge, my registered agent did not receive a notice of that hearing either.
All right. Rather than doing any kind of, it really wasn't sworn testimony, so no cross-examination at this point. I think what we'll do is, I appreciate your background on this, gives me some background I did not have previously. I think what we'll do is we'll let the city move forward with its case. In the four of you will have an opportunity to respond as you see fit.
Sounds good.
All right? All right. Mr.
Thank you,
Dewar,
Your
Ms.
Honor.
Dubridge, yes.
I'll start, and then we'll have testimony from city staff. I really don't object to any of the representations that have been made as part of the opening statement. It is consistent with what we were able to find. Again, as I mentioned earlier, we have not been able to obtain a copy of the escrow agreement, which would have set forth many of the terms, the specific terms and conditions. However, in April, there was a hearing before Your Honor, and the then city attorney, Matthew McConnell, did provide Your Honor with the facts that had been conveyed to him regarding the essence of the escrow agreement itself. And Your Honor, those facts were memorialized in your finding of fact and order from April, that was entered on April the 13th, again, shortly after the closing that transpired between the parties. A copy of the order was sent to the respondent's property manager, Matt Johnston, and it was also mailed to the respondent at 200 West Cameron Road, Falls Church, Virginia, on April the 14th. So the first matter that we would like to basically bring, and I have to add that Your Honor did retain jurisdiction to enforce the terms and conditions of the settlement agreement, and you were also authorized the parties to move forward with it and to take whatever actions were necessary. No actions have really occurred. We recognize that the new property owner has continued to work on the property. However, it still is not in compliance. So the 90-day period that the parties thought would be sufficient turned out not to be, and that was in 2022. And yes, we did have several storms thereafter. However, as it stands today, it is my understanding that the property is not in compliance, and at this point, I'll defer to Mr. Dwar to talk about the compliance component and also refer to our building representative.
Mr. Dewar.
Mr. Special Magistrate, part of the process for a lien reduction and the reason why there was this request or a settlement agreement was that the property could not have gotten a lien reduction because the owner of the property at that time there were existing violations on the property, as well as those violations were not corrected at the time. So for him to be able to sell the property, he had to have corrected the violation. So again, contingent upon this agreement and the settlement was putting funds into the escrow account, as Ms. Stuparich mentioned, is contained in the order. Because the property was not compliant against district holdings prior to it being sold. So the sale was again contingent on holding funds in an escrow account for the new property owners to bring the property into compliance within that 3-month time frame.
Okay. I know there was some discussion about lien reduction, and we aren't anywhere near a conversation about a lien reduction. I think you had made the comment, sir, that that there is a process for a lien reduction, and it's something that we've handled previously. I've handled it as special magistrate, and it usually, as Mr. Dewar indicated, it does come after compliance has been achieved. All makes sense, and that goes into the decision as to whether a lien reduction is appropriate, as to whether there's been prompt compliance with a previously issued order. So that part I understand. So we're really not focused on lien reduction. That could come later on. I'm not saying I'm not inclined to consider it, but I don't think we're talking about lien reduction today.
Agreed.
I think we're talking about the status of the property.
Correct.
And I'll disclose to the parties, I did drive by the property, probably saw me cruising the property this afternoon, and I believe we're talking about the white building.
Both are white. Both are white.
Okay,
Either one.
550
Yes, sir.
is on the east side of, I'm not sure what the north-south road is, or the one that,
Big one, yeah.
yeah.
One with the pool.
Got it, all right. And then it looks like there's another piece of property that's attached to the white building. It's a single story. Is that part of this conversation?
I believe you mean like a second story. This is the same building.
Same building, okay, all right. Okay, it's just because I wanted to see it, so I had a visual as far as where you are with your repairs and that. So I think we're talking about the status of the property, and then the question is the city, will I authorize the city to move forward with a foreclosure action?
Your Honor, we would like to present testimony from our building representative regarding the current status of their permits that they have.
Joe Boland, to the stand, please.
All right. And ma'am, if you can give me your name again, please.
Sure, my name's Joanne Boland, Permit
Spelling of
Administrator.
your last name is?
B-O-L-A-N-D.
Boland. All right. And I'm going to, actually, we'll start swearing people in. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Okay. You may proceed.
Okay, instead of going through, since this is an old permit, I don't know if you want me to go all the way back to when it was first submitted for review. That will take probably an hour and a half, going back and forth with revisions. I can tell you right now, for a permit that was submitted in 2022, inspections that have been performed, 5 inspections. First inspection performed 5/17/2024 for building, windows, doors. There was no product approval on site. There was not a permit placard on site. It was failed. There was an inspection performed on 5/21, which passed for the windows and doors as well. The building is open from the pool side of the building. They're saying alongside quarry is locked up. So they approved that one on 5/21/2024. There was a building framing on October 6th, 2025, partial pass. Says all framing inside, all individual units, okay. There was an electric temp pole inspection performed on 10/27/2025, that passed. And there was a temp to permanent power inspection performed on February 2nd, 2026, was canceled by Inspector Jason Steele, not ready for permanent power. I assume you meant to schedule for temp saw pole hookup. Inspection was passed and released to Duke Energy on 10/27/2025. It was not hooked up, and now it looks like the meter can assembly has been removed. It will need to be fixed before any further action. Those are the 5 inspections that have been performed on this property.
All right. Anyone from the ownership group, past owner or current owner, have any questions of Ms. Boland?
Well, that last comment is,
Come on up to the podium, sir. If you could state your name, and this is an opportunity for you to ask Ms. Boland questions.
yeah, this last comment is on the wrong job. That, the one being canceled by Jason for the temp to power, whichever one you just
Speak
had
into
right
the
here.
microphone,
So that's
sir.
on 5.
Yeah, come on a little closer. It's Mr. Pavick, right? P-A-V-E-K.
He did that comment for 600, which is the same building directly
Other
across
side
the
of the
street.
street.
Yeah. We had not even are ready for that inspection, so maybe that was just misfiled and then at the wrong one.
Yeah, he could have put it on 550 instead of 600.
Yeah, I mean, but there's been a multitude of things with this permit. So I would say I think I'm the second or third GC on this one, on this project. And so when I inherited it, there was definitely some violations that we had to clear up. But this has kind of been like a moving target. I had a meeting with Jason Fitzgerald, I believe is his name, the fire chief. When I was there, he told me that this building was owned by, not this gentleman, but the previous owner, the Russian lady, and that they basically were, cooking meth in this place. It was very run down and a rough, area. I don't know anything about that. Upon my inspection of the place, they had actually cut to put air conditioning, in the wall, just like plug-in ones, and they actually had cut through like venting stacks and were, breathing in like waste into the building. And so I had known that there was some issues, and then after speaking with Mr. Fitzgerald, he told me that on the second story, there was basically a problem with the subfloor, and we needed to pull, he's like, you need to go check that out because there's a problem in there. So obviously if the chief of fire is telling me that there's a problem, I need to go fix it because I had been notified. Well, when we went in there, we proceeded to go beyond the initial part of the permit. We had to, this is when Mark Vasquez was here. We had to go back and we had to redo all of our, so there was a pause on the project for an extended period of time for us to go back and it'd be a level 2 or level 3 and get that solidified. We were able to work everything through, get to a level 2, and then we had to introduce additional scope of work to the property. Underground fire protection being one of them. So we had to go run that whole course in order to get back to a point where we could actually restart and push the project along. The hurricanes came, and then, we had demoed. The hurricanes came, and then we had another long delay because FEMA was in here. They thought that it was going against the FEMA numbers, and they're like, you're over your threshold for your 51%, and we had to stop everything and say, no, our permit was from before. The work we've done is before. In truth, the hurricane didn't really affect us too much in the sense of damage to the building as much as cleaning up the mess that was kind of all around us. So there's been, some longer project delays in here that we've had to work through. Additionally, there was another revision that needed to be done for the permit where they were building, we had to build a deck to hold the HVAC in there. That took some time to get in there, so, and then there was another fire permit that was pulled on the property where the city came to do the backflow, and they just put the backflow over here in a different spot, and then we had to resubmit drawings. And so I'm not saying the whole timeline is that, but there's definitely been some, a lot of revisions and, you know, us going back and forth to try to get everything where I could get it approved and actually move the project along.
Regarding 600 Quarry Avenue,
Should have been the same note.
more inspections.
So 600 Corey is not the subject of today's
So-
hearing.
But he's saying that that inspection should have been on this one, but
Yeah.
600 Quarry had the inspection for the temp to permanent power and passed on July 13th.
First. Oh, well, yeah, he just did it today. But it was, he did the inspection on July 1st.
Okay. And Mr., again, I'm jumping ahead here, Mr. Abraham and Mr. Diane, do you own 600 Corey also?
Yes, sir.
Okay. All right, so not the subject, and is that occupied now?
No, not yet. We should have a CO building final this week.
Okay,
I want to see, yeah.
all right. All right, Ms. Boland, anything else that you wanted to add?
No, I think that would be it. Like I said, if I were to go back to 2022 and go back and forth, it would take too long.
I don't think we need to go back through the history, other than I'm surmising that the property is still not in compliance as we sit here today. I'm not ascribing any blame on anybody at this point. I understand, you know, with Mr. Kastenbaum's involvement, we have an international pandemic that intervenes, and then 4 years later, we have two hurricanes that hit the area unlike anything that we had seen in the last 100 years. Certainly understand that, but I think from my perspective, the question before me today is the status of the property, and I'm surmising that the status is not in compliance. Sounds like Mr. Pavic and his crew working towards compliance. City is working with you, whether it's to your liking or not, I don't know, and I'm not going to get into that, but that's a matter of communication between owners, GC, and the city staff. But I'm assuming at this point that the property is not ready for occupancy.
No, sir.
Okay.
And I would also say that this new building officials, 5-star rating. We were just talking about it this morning.
I'm glad to hear that.
Yeah.
Okay.
The new guys have been very helpful in getting
All right.
everything through.
All right. Ms. Boland, anything else to add?
No, sir.
All right.
Thank you.
Thank you very much.
So, Your Honor, as far as the first part of today's conversation at this hearing is the status of the property. And as you mentioned, we definitely agree that the property is currently not in compliance. That unfortunately, because of the various things that have happened, this permit was not the property was not brought into compliance within the 90 days, whether that was realistic or not. And they continue to move towards coming into compliance, but they are not in compliance. In closing on the status component, I just wanted to bring to Your Honor's attention your paragraph 7 in your order of April the 13th. And there you have acknowledged that the respondent, the seller, District Holdings Florida LLC, has prepaid the estimated amount of the fine, and that the fine would continue to accrue. In paragraph 8, you made a finding that the title company was handling the transaction. They would hold the escrow in accordance with the escrow conditions, which we have not been able to identify, or by further order issued by the magistrate. So we would be requesting that Your Honor consider issuing an order directing the title company to release the $86,500 to the city as a prepayment representing a partial payment of the existing lien.
That's we haven't gotten to the issue as to whether I enter an order authorizing you to proceed with the foreclosure yet.
We have not.
Okay. All right. Mr. Kestenbaum, I know you have an interest in that $86,500. That's why you're here today. Usually we would not see a former owner here unless the fine was still, you were still subject to the fine, but it sounds like your agreement with KAO was for them to take it subject to the fine, with the $86,500 that you did not receive at the closing being held by the title company. And
Correct.
I don't know, yeah.
I will tell you also.
Come on up to the podium, please, so we.
In interest of full transparency, when I sold the property to these gentlemen, part of the purchase, actually, I think all of the purchase price for that property was in the form of a promissory note. So I have a lien on the property that I believe is junior to the lien that you are asking to be foreclosed. That's another reason.
So you still have an interest in that as basically the lender.
Yes.
You've got several hats on right
Yes.
now. Okay. All right. Let's discuss the escrow then. So come on back up, Mr. Kestenbaum. So Ms. Stuprich, the city attorney, is asking me to enter an order directing the title company to release the $86,500 to the city. Your position on that is what?
I would object to that order.
Okay. And the basis for your objection?
I don't think they're entitled to it. They're not a party to that escrow agreement. The escrow agreement is an agreement between District Holdings Florida and KAO Capital Florida. I don't see what interest the city would even have in those funds other than as, you know, I guess a payment on the lien, which I acknowledge is there. Our hope is still to request a lien reduction.
Okay. So what I'm hearing is the amount of the fine is 6 figures now, in excess of $300,000. And I don't think we have an accurate, we don't
We
have
don't have
it.
the number yet.
We don't have the number yet, but
Well, we have it, but that's.
we haven't gotten to that. So we're going to hear that number later on. And the city is asking for me to enter an order that would authorize the $86,500 to be released to the city, credited towards that number, so that number would be reduced. I'm guessing your position would be, along with the current owners, would be to come back and ask for a lien reduction, probably.
Correct.
All right. So that's, as I said, that's not before me today. So the only issue is the enforceability of the order that I entered on April 13th. We had our hearing on April 11th. 2 days later, I did the written order, and it was represented to me that the title company was informed of the city's interest in this in this money. I did not look at the escrow documents. I left that to the city attorney and to whomever was working with you on the sale of your property to KAO. And I'm assuming whoever they may have had as an attorney was looking at that also. So
Correct. I was, and KAO's attorney was. No one from the city ever contacted me. I do know that they talked to my real estate broker, but my real estate broker would not have had authority to enter into any agreement on my behalf.
All right. All right. Ms. Stuprich, your next point.
You would like to get a chance to speak, sir.
All right, let's do that now. Are you okay with that? Any objection? I know we're
Yes,
taking
mean,
things a little out of order.
This is quasi-judicial,
Yeah.
and
So-
we really would like to get this resolved somehow.
Yeah.
Yeah, I think
All
that's
right. Let's
that's
do-
everyone's
let's
goal.
do
That's
this.
definitely my goal in flying down here.
Mr. Kestenbaum has spent a lot of time at the podium today. He's represented that he's an attorney in Washington, D.C. area, in either Virginia or D.C. Why don't we assume and have him acknowledge that his testimony was the truth, and that we'll treat it as sworn testimony.
No problem.
All right. That way we don't have to have him come back up. All right. Thank you, sir.
Sure thing.
All right. Someone from KAO would like to speak. Come on up. And then why don't we have you, before you speak, identify yourself, because obviously we have a recording going.
Yeah, sure. Omer Ben Abraham. I am a co-owner. My business partner over here. A little bit thick accent, so hopefully you understand. If you not, please let me know, okay? So I prepared a little bit a note over here. First of all, we understand the city's concern. Okay, it took a little bit while, but we all know that, by saying hurricanes and stuff like that, it's not like a minor thing. Hurricanes, people were here with canoes on the street, so we know that. I'll be a little bit less official. I'll try to. I'm just talking from my heart. And on this property, we had a lot of.
Let's do this. This sounds like testimony.
Sworn in, yeah.
Right. So I'm going to have you be sworn in.
Sure.
Do
Do you have another option, because Jewish people doesn't swear?
I allow you to be, you affirm, I always use the word swear or affirm. So do you affirm that the testimony you're about to give will be the truth?
Yes, sir.
Please proceed.
So we understand the city's concern. Okay, we're here to work with you. You saw us dealing with the hurricanes, with FEMA, with everything that we had. It's cost us a lot of money. I will tell you that. It's not nice for us not to have an occupied building. We all know that. We're here to tell the city and to you, Your Honor, that we're here to make it all the way to the finish line. You saw 600 Corey, which is the same building, same materials. We tackled whatever the city asked first, which is the exterior. It was an eyesore for the city. Yeah. Guys. The city asked for the exterior of the property to be tackled first, and when we did that, it was an eyesore. We understood that. We immediately went with windows and exterior, all the painting and all that, just in order to show the city that we're here to work. We are in a finish line with 600 Corey. We show you guys that we are accountable. We are here to work. We have the funds ready. We have the contractor here. We have the former owner here. We work together on this one. This is a major thing for us. We're not fighting or stuff like that. We're here to work together, and I believe that it shows you guys that we are serious. We flew in. We have a cruise over here, and we are here to tell the city and to you, Your Honor, that we can provide the city, if they would like to, a Gantt in about within 72 hours ish, to give you like a full Gantt of the project, to show you start to finish. What is it that we're going to do? The funds, if you need to, a proof of funds, whatever you guys need to, in order to show out you guys that we are here to work and to bring it to the finish line. I think it's going to be the benefit of the city, the people in the St. Pete Beach, for us as an owner, for Mr. Kassenbaum, for everyone here, just to bring it to the finish line. I think it's going to be a win from our end, and we can provide more places that are brand new for people for tenants to be here. We talk to the people over here. We get great comments. Your Honor, you drove over there. You saw the property. You saw everything, and I hope that you like it. Yeah. But the selection that we made everything with the thought that, hey, whoever going to live here going to enjoy and going to get a great product. And that's what we want to. That's what we're about to do the same on 550. So I know that, as Anthony just mentioned, we have a great guys working with right now with the city, and hopefully that we can go hand to hand. We want to make it happen, guys, and we're here to work.
So I'm clear, 600 Corey, how many units are in?
7 units over there and 14 in another one. Yes,
okay, and the intent on the rentals on those units, what's the duration that you're planning? Are they?
For 600 or 550, sir?
Let's 600.
600 is ready to go. That's it. We have already.
How long will the leases be on those? Are those?
It's already. We already posted. It's already. We have a lease up company. Everything is in place right now. We're waiting for the CO.
Yeah.
And that's it.
And what's the duration of those leases? And I'm not sure what zoning district that's in and what the restrictions are as far as.
We went with the long term.
Are they short? They're short term, long term.
Long term.
Long term.
Long term.
Long term meaning at least. You're talking about a year.
Yeah. We want a year, yeah, but I think that the term, if you, I'm not, I think that it's more than a month, but we are shooting for a year, yeah.
Minimum is 30 days in that zoning district is what I'm hearing. And again, this is not a zoning.
We want a year, yes.
All right.
Yes.
Okay.
So we want to provide.
And what are you planning on doing with 550 then? Same thing. Okay. Because the city of St. Pete Beach is very aggressive in enforcing its duration, and if the zoning ordinance doesn't allow short-term rentals, meaning 1 week or whatever the term may be, I mean, I want to make sure both of you understand.
We're not here to trick no one. We're here to make it. We are good boys, so-called. We will do whatever the city wants us to do. We'll make sure that the people get the best units ever.
Okay. All right. And Mr. Avraham, you mentioned that you have proof of funds to finish the job. So, your financial arrangement with Mr. Kestenbaum then is that you're going to finish the building?
Yes,
at some point there's money that's paid to him, or will he continue being on the note?
Right now, the note, he's on the note, as you can see. We'll finish the building, and we're going to start. There is an the note will end sometime. Yeah, there was. I don't remember the specific date, but there is a end date to this one.
Yeah, I'm just curious, again, I'm trying to get the full picture here.
Yeah.
And I think the city has probably not had this opportunity to talk to you because I understand Mr. Kestenbaum's from DC area, Virginia side. Mr. Abraham and Mr. Dayan, I think I saw a Wisconsin address for both of you. All right, so, and this is your first time that you've had a chance to meet some of the city employees, or have you?
A few times.
What, 4 years ago? Yeah, 4 years ago.
All right, all right, all right. So I'm sensing that you're renewing an acquaintance now that started 4 years ago, but I think for the city to bring me in means they're at the end of their patience, and they want me to move this along. And I have certain tools in the toolbox all the way up to foreclosure, which is probably equivalent in, again, not as serious, but equivalent to what would be death penalty in the criminal case where you lose the property and all three of you end up walking away without anything. So that's how far this could go, and that's why I think the city wants you to understand how serious they are at this point. Whoever wants to go ahead.
Again, one sentence. We want to finish this project. We want to finish. We want people, the tenants over here, to get the best product. I think there is a lake of good products over here, which is units, long term.
Mm-hmm.
We want to have the chance. We can show you guys whatever you want. Simple as that. We're here to work. Hopefully that you like 600 because I think we did a great selections. Let us do it. I think that we're not going to disappoint you guys.
So, Your Honor, there is one, I'd like to make one statement and then ask one question. The statement that I wanted to make, I was not the attorney that was present. However, I did view the video of that hearing, and there has been reference made to 600 Corey. 600 Corey apparently was able to come into compliance. And at that point, there was a representation from Mr. McConnell that there was a settlement reached on the lien on 600 with a reduction from $64,000 to approximately $13,000 or some ballpark of that.
Right. Yep.
So this, I just wanted to remind everyone of that this is not an isolated incident. This was this whole idea of the 90 days and the city being able to recover its money, payment of the lien was not, the city, that was really part of a larger deal, which was to try to bring these properties into compliance. And I think that's an important fact to be remembered. And then the one question I want to ask you is, as the buyer, as the current property owner, are you opposed to the city being having the $86,500 being released to the city?
Yes.
On what grounds? Why?
Again, so you wanna help me out on this one? Yeah. I'll have my colleague over here to my co-owner to help you guys.
All right, Mr.
He is more involved in this 86,000.
All right, sir, your name,
Hello,
please.
everybody. My name is Kiefer Dayan. You got that already. Thank you for everything you guys said. Just a nice chance to actually say something in front of this in this forum. I believe this is not our only real estate deal. I mean, we're pretty well experienced and seasoned. There's a lot of people that will walk away from that property a long time ago. We're fighters and we are finishers. This property took a whole lot of bumps on the way in so many different aspects when we took it in, even the submittal of paperwork and the plans and the planning. There's so much to it. It's a very involved project, and we took it upon ourselves because we're winners, not because we're there to lose. I know that now it sounds like, okay, it's been 4 years, but it's been a 4 year of a lot of dirt and a lot of bumps, and we never stopped. It's factual. If you look at the process within the city to the engagement, the money that we put in, and then we had to shift when the hurricane came, money had to be shifted to 600, which was a rented product. It was like a complete product that it wasn't the nicest, but it was like we had tenants. All of a sudden, you need to put $500,000 there or whatever. I'm just throwing numbers, or a couple $100,000 there. And manpower, the people that we have to put to actually work. we had to shift there to finish because it's a smaller product so we can actually rent and make some money back. So there was a lot of bumps on the road, and I hope you guys see it and believe in us because we're actually here. We're working. We did a facade, we did windows, we did doors. We're here to fight and finish. I'm not a loser. I've been doing this. This is not my first rodeo. Been doing this for a while. Dealt with a lot of cities. Got to tell you, to be honest, just like as a tip for the city, I don't know how you're going to take it. Anthony's telling me that today, like the team is better. It's been kind of difficult too in some aspects, and I'm not blaming anybody. I'm just saying this is not. I've done hotel conversions that's been easier than what we're doing today. But thank God things are going good. You know, we're putting our efforts. We are all in, motivation-wise, and hopefully soon enough you'll see it finished. You know, like Omer said, we can show you again of the process. We hear very often. As an owner, I live in Wisconsin. I'm a father of 3. I have plenty to do. I have little kids. I have a full-time job beside that. So we're here because we want to win. We want to finish. All I'm asking is that you allow us to do that. Regarding the escrow, which is your point, right? I'm in a position that money should go toward the property rather to go to the city because we've done everything in our power from day one to actually comply or get it to compliance. And it's been, like I said, it's been a bumpy road. And so much money and efforts and people. I cannot even start describing. I can sit here for 3 hours and just like spill and complain. But I don't want to. I'm here to tell you guys, we've done everything we can. I'm here today. I've been here last week. I've been here 2 weeks ago. I've been here 4 weeks before that. We're flying in and out just to make sure everything is happening. 600 is finished. We put a lot of gas on it so we can get that CO. And we're riding back to 550. Please allow us to finish it, sir. It's a lot of money. It's a lot of efforts. Don't take it away from us. Like, give us the chance, the ability to show the city here. We're done. At the end of the day, we all have the same goal. City is not a real estate investor. City wants to see nice buildings and an upgrade to the, how do you say it, community. We're the latest and greatest on the beach, by far. I can guarantee it. You walk into my building today, I've seen what's going on. We are the nicest looking. The other one, also nicer looking. What it does, it's set up an example for the next building next to me. Allow us to do it. That's all I'm asking for.
So, Mr. Dayan, first of all, I did not swear you in, so I'm going to have you affirm.
I affirm. I can't swear, but I'll
that
affirm.
everything you just testified to and that you'll be testifying to in the future will be the truth.
125%, sir.
We'll stick with 100%. Okay. All right.
I don't like
Number 2, what's your timetable for completion of 550 Cora?
So we think we're going to do it at a certain amount, but I'm going to give you the safe zone, 6 months.
And we can provide you the Gantt, please. We can provide the Gantt so you can see it.
G-A-N-T, Gantt charts. I'm sorry. Sometimes our accent gets...
No, I got it. No, I understand you.
But we have the funds, we have the people, we have the motivation, and we just finished the exact same product.
Materials is...
Half size, like 7, this one is 14. Okay. So whatever we learned, or even if it's material-wise, problems that you learn within the way, like on the way, you know, you've been struggling with this, you learn, you can move faster. I know the time to it, it's quite a bit, but let me show you that we can do it. I mean, this is going to be great, you know.
All right. Thank you very much.
Thank you for allowing me to
All
speak.
right. Ms. Stuprich, did you have anybody else in the city that you wanted to have testify, or Mr. Dewar?
No, but I think Mr. Dewar, and it's probably more relevant for the foreclosure discussion, but if you could go ahead and advise everyone as to the amount that's currently due and owing.
The accrued amount for 1,441 days is $361,304. In addition to that, if I'm not mistaken, there is a for sale sign at that property? 550?
No, we don't sell 550.
No? Why was your inspection canceled in February of 2026, as Ms. Boland attested to?
Anthony, can you answer that? I'm sorry. First of all,
Come on up to the microphone if you could, please.
I'd like to say, first of all, where is that escrow, not escrow, I'm sorry, that fine that you got the 361,000 is from, and why aren't we aware of it? I'm the owner of the property. Please, that's the first question. Also, why am I not in compliance while I'm under your permitting requirement? Even though it takes me time, it doesn't mean I'm not working. Why are you punishing me for it? That's a question that I will ask. I mean, I shouldn't be punished. I should be driven by you guys to actually finish. And you're right. There's probably a patience span you can take, but we really went through quite a bit. Why making it harder? You know what I mean? Like, we're here to work, to finish. I didn't even know we have 361,000.
Yeah, so that goes back to the original order that was entered of $250 a day. The state statute authorizes the city to ask the special magistrate to enter an order based on a per-day basis, a per-day amount, and the city asked for $250, and it often is enough motivation for owners to get their property in compliance quickly, so they don't have to deal with a huge amount like $361,000.
Shocked.
We're now 4 years removed from that date, 4 years plus.
But within that...
So that's the 1,441 days times $250 a day. So, you know, the city, and the city has the authority to collect that amount. They'd have to go through a process if you don't voluntarily pay it to get that amount, or they can do a foreclosure on the property, and that's why we're here today. I think the question is, if you're able to work something out with the city, would I consider a reduction in the amount? You have a couple options there. Yes, I would entertain a request. I can't guarantee I would give it. I'm just telling you, it sounds like we've been through this process before on the other property where the fine was $60-some thousand and it got reduced down to $13,000.
That's before we bought it?
Right.
That was at the time you bought it, yeah.
Yes.
And that's how you were able to buy it. We have to remember that part.
Right.
This was contingent on that.
With the city's agreement.
I'm sorry, I need to object to that.
Yeah, Mr. Kestenbaum.
I keep hearing that from the city, that the city had to agree to something for the property to be sold. The city, to my knowledge, and correct me if I'm wrong, Your Honor, I don't understand that at all. The city cannot block a sale of property between two private parties.
I think what the city does is the city recorded the order that I had signed, which becomes a lien on the property.
Right.
That is disclosed in the title report.
Correct.
That these gentlemen or their attorney had that report prior to closing on the property, and it sounds like there was a discussion that they would buy it subject to the lien.
Correct.
It's knowing that it's 200, and again, they may not have known the details of it. I think they, whoever helped you with the sale for you to buy it, may have told you that we'll get this lien reduced, and again, that's not a guarantee. It's something that is discretionary on my part, and I've entertained, and I've reduced liens over the objection of the city. I've denied requests to reduce liens. I mean, it depends on the set of facts of the case. I just don't want to telegraph right now what I would do with a $360-some thousand lien, because I really need to see more progress before I would even we'd start having that conversation. I think in this particular case, the city is frustrated. This is their opportunity to get your attention. They have your attention now. The best thing that the four of you could do would be to meet with the city, develop a plan, whether it's a 3-month, 4-month, 6-month plan, and get the plan in place so the city can close the books on this particular piece of property, let you get back, and if there's money left over from the $86,000, you'll have whatever your agreement is with KAO, you'll be entitled to that, and then you put them in a position where they can start generating some revenue to start paying the note that you are holding on the property. I get all that. Realistically, that's what needs to happen, and it sounds like, I can deal with this today. I'd much rather see you have a conversation with Mr. Dewar and Ms. Stuparich and see if you can find some kind of common ground on where we go from here.
Yeah, I would like that very much as well. I think, there's been a lot of engagement from these gentlemen and their contractor with maybe the technical people, the building people, very regularly, my understanding. I think maybe it's just not communication between those people and whatever the division is that you're all with. I could be wrong. Again, I don't know, but I think what you're hearing maybe is some frustration from them. I mean, listen, I will. My view is I'm a little bit. I will tell you, I was shocked when I saw that there was a hearing in 2022 within a week or two after the property was sold. The city clearly was aware that the property had just been sold. I saw that these gentlemen were not present at the hearing. I'm kind of shocked that a hearing was held about a property where you knew ownership had changed hands. They were not given notice. I, as the prior owner, I was not given notice. My property manager may have been given notice. I don't know. I'm not working with them anymore. The real estate broker may have been given notice. I don't know. But the sale had closed and he got his commission. So, I mean, listen, you heard Kiefer,
So Mr. Johnson was present at the first hearing. He spoke with authority. Whether he was communicating with you, the city and I, as I sat here as special magistrate, believed him when he said that.
And I'm sure that everything he said was true.
He had authority, right. He had authority to deal with this matter.
And he did.
And he was able to put together a sale subject to the lien. And unfortunately, there were a series of events that didn't allow this to happen with the speed it should have happened. So here we are 4 years later.
Your Honor, also your findings of fact and order directing compliance, imposition of a fine corrected, does say that the city is authorized to conduct re-inspections. The case is set for status before the special magistrate on April the 11th at 1 p.m. So they were provided notice in your order itself.
Yeah. I mean, Mr. Johnson, we had deemed that we had jurisdiction. Whether you received whatever notice was sent to your Virginia address or not, I don't know. But Florida law shows you have to have proof of service. And then when we have a property manager show up, that tells us somebody was aware of this case.
Yeah.
Whether it was you or just Mr. Johnson not communicating with you or not giving you all the facts. Sounds like he was working on trying to sell the property, which he did. Here we are, though, 4 years later, and we still need to get this matter.
Understood. I just, you keep, reading, findings of fact from a hearing that occurred 5 days after, I think 5 days after the property was sold, where you knew that transaction occurred, clearly, and you knew that the owners of the property weren't present. I don't think you were able to show that the new owners of the property had notice of that hearing. I had no idea that hearing was going to occur. So obviously didn't disclose it to them because I didn't know. I would move to say that those findings of fact, and I'm not saying that your findings of fact are erroneous, but I'm not sure that we can take them as, well, I don't want to say that. I question the fidelity of the city in moving forward on an enforcement action on the property under those circumstances.
Yeah, my assessment would be that the lien would have been disclosed in the title report.
It was.
And the buyers would have been aware, or should have been aware. That would be notice under the legal definition of what notice was required. And whether they needed to be added as a party at that point, I don't think so. I would obviously want to hear from Ms. Stuprich on that, but my assessment is the order stood. It was recorded, ran with the land, and whoever bought it subject to that fine being imposed.
Oh, we're not, understood, and we're not disputing. We're not disputing that. I'm just questioning the notice of that April 11 hearing and whether it was really properly done. Mm-hmm. I don't believe that any notice, even of the original proceeding, was sent to my registered agent.
We would have to go back into the original code enforcement case, but we're not here today for that.
It's not even worth revisiting all that. That's not what I'm suggesting. But
So
I understand it could have been a jurisdictional issue had it been raised in a timely manner. Here we are 4 years later, and at this point I'm not going to render any kind of decision as to whether the city had jurisdiction over the previous owner or not. I think we're here today to try to deal with this, and it sounds like we have parties that are willing to make an effort to complete the project in a now timely manner. And the question is whether the city wants to allow you to do that or whether they want me to move forward with an order authorizing foreclosure. That's where we are.
So, Your Honor, again, as I mentioned, the property is currently not in compliance. It has not been in compliance for approximately 4 years. I've heard the testimony, you've heard the testimony that they're willing to move forward quickly, but I have to note that the testimony from our building official was that the last inspection occurred back in February, and today is July. And it took a lot of work on our part to try to do the research to try to find out, well, what is this money? Where's the status of it? How come it hasn't been released to the city as we believe was authorized in your order? You know, both of the parties have objected to giving the city the 86.5 that is in escrow. They currently owe the city over $300 and something thousand, $361,000. 86.5 could be a partial payment towards that, and we could consider then perhaps waiting a bit before we move forward with a foreclosure.
Yeah, Mr. Dewar, my recommendation today, and again, I'm not trying to defer making a difficult decision, because I really don't see it as a difficult decision. What I would recommend, though, is since you have the parties present, and I don't know if you're here for a few days or not, but try to meet with the city officials and get a...
Tell us what to do.
Get a...
They're asking for $300,000. I didn't understand what they're asking for right now. You do ask the...
Yeah, they're entitled to $361,000 as we sit here today, okay? And the question is whether, and the way they would collect that would be to start a foreclosure lawsuit that would be filed in Pinellas County that you would have to respond to, and that will take some time. It'll be some expense on your part also, because unlike this proceeding, more than likely you're probably not going to want to represent yourself.
What's the benefit? Who benefits from that?
Well, the benefit for the city is it gets your attention. And I know that you've been making an effort. You've shown the effort you've made on 600 Corey now, and you're focusing on 550 Corey now. That's great. But I think the city is frustrated at this point. And again, what's happened between February and July, I don't know. You know, again, has it been total radio silence? I don't know. I'm hearing from Mr. Pavick that the city staff that he's working with now is much more responsive and easier to work with.
Yeah, I would like to say, the city, and this is just from my experience with them while I was the owner of the property, did everything they could to make it more difficult and to make it as difficult as possible to bring that property into compliance. It sounds like, from what I've heard from these gentlemen, at least up until recently, it was a lot of the same. It sounds like the city may have a vested interest in dragging it on as long as possible so the fines continue to accrue. You know, I'm not going to comment.
So that's part of my calculus.
Yeah.
In other words, and again, I can't really hear it today because I really need to hear from the city as to what their employees, because their employees may come back and say, well, the GC was hard to find. And again, I'm not saying you are. I'm just saying two sides to every story or three sides to every story like this when there are multiple parties involved. So, but that's not something that we need to address today. The question is, and I did hear Ms. Stuperidge say the city might be willing to consider deferring a decision on the foreclosure, giving you an opportunity to meet with the city, put a plan in place, take the Gantt, show the city.
With the delivery of the 86.5 to the city as a partial payment, a prepayment.
On what basis under law would you have to receive a partial payment on a lien? I don't understand.
We can accept a partial payment on the lien, which would draw down the final amount that's due and owing.
Are you willing to release the lien?
We don't.
No, I don't think.
That's not a full satisfaction of the lien, but it would be a partial payment that would buy you a little more time, and then you could come back and ask for a reduction if you wanted to do that. You would have already prepaid 86.5 towards whatever that reduced amount would be.
Yeah, you're hearing from us, you're not going to get a voluntary agreement from us to do that. I will tell you, it's extremely emotional for me, how incredibly difficult the city was and made my life and my property manager's life throughout 2020 to 2022. The additional amount of money that I had to continue pouring in to that property, only to hear that the city was throwing up further roadblocks and making further demands. My mental health suffered greatly. continues to suffer. And now I've stuck these gentlemen, with the property. Stuck maybe isn't the right word. But I felt, when I heard how difficult it has been for them, when they, it was, I would tell you guys, if you'd rather me not.
I can tell you
yeah,
that.
I would tell you when they came to me in December of last year, saying that they needed reprieve from payments on the note, and explained to me what the situation that they was in. I felt they were in. I felt terrible, and so of course, I did that, and in fact, I even they're raising additional funds to complete the property. I committed additional funds to them because of how bad I felt about it. It was, but I will tell you that the saga of this property and what it has done to my life is, I don't know, maybe one day I'll write a novel about it.
Mr. Abraham, you wanted to make a comment?
Well, yeah, it's, we share the same, I don't want to say the same story, but same feelings. The amount of money that we spent could go to way better places than interest, than stuff like that. It's like throwing money to the garbage. We all have families over here. We're all feeding kids, and we give charity. I prefer to give this one to a charity than to throw it to the garbage. Payment after payment, 4 years of payment. If you're saying, again, I'm repeating the same thing, but you're saying it's a 3 months and hurricane came, I'm telling again, you know that people here, there's videos of people swimming with canoes over here. It's not a regular rainstorm. People with canoes on the street, and it's made us going back to 600 Corey, renovate the whole thing, raise another money, go back to our investors that are not believers anymore. Hey, another time. You think how many times we came back, hey, we need additional capital call. Man, how many times? We're here to work. I also want to say, again, it's not the situation right now, but it's kind of a double standard, I feel, that when you have the ability to control on the inspection time or caller time, and you find me $250 a day. Okay, so you can drag it all the way to 7 years. I'm not saying no one did it, but I'm saying it's kind of, when I'm thinking about it right now, it doesn't make sense. It was super hard back then even to get an appointment. We had multiple emails. I came here, I've been thrown out from here, not thrown out, but, oh, you need to get an appointment. I need to get an appointment. Okay. An appointment, you're calling, no one is answer. Emails, no one is an answer. Man, you're giving service. Give the service, man. I'm here to work with you. It was that back then. Right now we have better people. I'm not going to blame no one. I want to work with the city.
I think
let us finish.
We understand that at this point. I'm not on the city side. I'm the neutral. I'm the umpire
Right.
that calls balls and
I'm
strikes.
just commenting on the same comment that
And what I'm trying to do is, Mr. Pavitt, go ahead.
Just to kind of add to what he was talking about, immediately following the hurricane, it was like part-time hours here. You could only come in for a short period of time to talk to anybody. It wasn't just us. This was experienced everywhere, Right, no, I got you. And just some other contributing facts to why things were delayed, just to give some added context. Obviously this is Florida. There's a lot of labor, right? We try our best as builders to get real guys to come in. They sign trade agreements that they're going to use real guys, but that's not always the case. Throughout the duration of this project, I think in July 1st, 2024, they made a law change here that if you had undocumented people, it was a felony. Immediately a bunch of labor left the job, right? I probably had to recrew this job, I would say maybe 5 times. Had to go get different guys because it was just hard to get crews. Beginning in February, going back to the beginning of this year, we had a huge influx of ICE was here. A lot of people, I personally lost like 20 guys in like 4 crews. So you had a bunch of jobs that all of a sudden were just sitting, and everybody was fighting for labor to try to get things going. I'm not talking about the lien. I'm just telling you like what the market conditions were and what everybody's, just to give you an added understanding of what's going on.
And I'm well aware of what's going on in Florida in the last, going back to 20, with COVID, and then obviously with the hurricanes, and then more recently with labor shortages.
Yeah, I mean.
Certainly understand that.
I mean, and
again,
that's all like a force majeure. I mean, if the
city had
government,
no control over those three events, but I understand that what the city does control is its employees, and there may have been a lack of communication or miscommunication between owners, GC, and city staff. I think what I'm suggesting now is,
I mean, this is my third building official or fourth building official that I've been on since this project. There's been a lot of turnover.
Yeah.
No, it says something. We're here
All right.
to work. It's not
All right.
hey, we left the job site on February.
Ms. Duperich, final
Your Honor,
word?
Yeah, I think we're starting to become a little repetitive, perhaps.
are.
I know I am.
Because you didn't lose money from your pocket.
My-
We lost money, a lot.
All right, let's do this. What I'd like to do is, we've been here for an hour and 20 minutes, and I'd like to go ahead and have some kind of
I can
resolution.
just do a closing, basically. Again, as I've stated, that based on the documentation, the testimony, there's no evidence that the property is in compliance at this time. And with that said, we defer back to your order of April the 13th, where you retained jurisdiction, and you did state in the order that you would have a further order issued by you to release the 86.5 that's being held in escrow. It was stated that it was prepayment of the estimated amount of the fine. We believe that the city is entitled to that money at this time, and that's our statement. If they in fact are sincere in doing that, there should be no issue in releasing the money to the city, because we have to deal with what are we going to do with $361,000 lien that's due and owing. The 86.5 would simply be a down payment or a partial release or a partial payment of it. That's all.
All right, last comments from ownership. Mr.
Sir.
Dan.
I ask that you please be factual. I know that that's what you be. You're neutral, right, in this case?
I am.
So, effort shouldn't be punished. Especially full gas efforts. We do know what's happened here. We talked to a bunch of properties owner here that's the same, going through the same process that we've been through. The city should help. And we're here to work with you guys. I'm telling you, please, in your face, that I'm ready and able, and we will engage. I'm here till tomorrow. I have to fly out tomorrow. We came for a couple of days for this, especially. We have all the plan laid out. Forecast is all cleared up. 600 is almost finished. We shouldn't be punished based on efforts.
So when would you be available to meet with?
I will be very happy to meet tomorrow early a.m. because I have a flight to catch in the afternoon. Gladly. I've done it many times here.
All right.
If not, whenever it's comfortable for you guys, give us like a week or two.
I'll fly in.
Yeah.
Gladly.
Whatever it is, we'll work with you.
I've been coming here every
All
2
right.
weeks.
So
We're
my,
willing to do whatever it needs.
There's no reason to punish us for efforts.
Told you what we needed.
yeah,
You want money, but do efforts, and we have, I want to say something off the record.
no, it's on, actually, it's on the record,
Oh,
so
it's
go
on-
ahead.
on the record.
Yeah, there's no off the record here.
Okay, I don't think it's gonna be like helping no one by finance, again, 300,000, I can put it in the property. Your people, our people can get a better property, why not? We got suffered enough with money, I'm telling you, so much money that I could give to the better place. And so you and so on everyone. We want to take this money, put it in this property, finish the project, say goodbye, shake your hand and tell you guys, thank you for letting us be. It is what it is now. Again, I don't understand how it's gonna help someone to come and just, bring us all the way to the floor. We're already there. We want your help right now. We want your help.
It's degrading. It's not
So,
We want you guys to feel
Yeah.
for us a little bit, and we want to finish this project. Think about it. You came all the way to the mountain, and you cannot enter the land. We want to be there. We have the materials, the contractors, the funds, the Gantt. Show us, tell us what we need. We'll make it happen. If we don't deliver, do whatever you want. But give us the chance.
all right.
Yeah,
Any interest?
The further thing I
Go
would
ahead,
like to-
Mr. Kestenbaum.
I know it's been a long time already. The ask for release of the 86,000, first, I don't think there's a legal basis for it without our consent. But also, and we understand that, and you've indicated you're not, ready to express any opinion on a lien reduction, and I completely understand that. But the release of the 86,000, would prejudice, us in at least, some amount of that lien reduction that we would hope to get. And I would also further request, respectfully, based on the testimony that you've heard today, that further accrual of the fines be paused while these gentlemen continue to try to bring the property into compliance.
Yeah.
Your Honor, we strongly object to that.
Okay, and I get that. I understand, and your objection is noted. I'm not going to pause the fine. The fine will continue on as we've discussed, as the original order provided. What I would like to do is, I'd like to give everybody some time to meet, whether it's tomorrow morning or when you come back in a week or short notice. I'm willing to give everybody a month, 28 days from today. You're still meeting on second Monday of every month, I believe, correct?
Yes, sir, but I'm a little bit concerned about the meeting because we have been, as these gentlemen have said, we've kind of met over the last 4 years and we're still in the same place.
So I think this is the 11th hour for everybody, for the owners. They understand that. I do believe they're sincere about completing the project. They did complete 600 Corey. Again, I don't know that to be a fact. I've not been inside, but it looks like it's a near completed project. I believe I heard that there's an inspection coming up for the C of O fairly soon, on Friday. So, and again, I think this is an opportunity for the owners and the city to meet one last time to develop a plan. If the plan doesn't come out of a meeting, then at that point I'll be ready to make a decision, and the decision will be, there will be some kind of fine imposed because it has been a long haul for the city. The city has incurred substantial costs, and I understand there's frustration on the part of the ownership group as far as performance of certain city employees, but the good news is I'm hearing also that you found somebody you can work with, and that's good news. So,
Will you be there, sir?
no,
A third party will be there, someone will be there?
no, it's between you and the city. Yeah, yeah.
Oh, yeah, we did like a mediator, someone that will help us.
Well, I think you're all adults, and the city knows what the code is. You should know what the code is, and I think at this point it's a question of timetable, proof of funds, when you can deliver without coming back and asking for extensions. That
They will show it to you, like.
I'm not the person. I'm not in a position to approve a plan for you to follow and dictate that upon the city. The city needs to look at the plan and decide whether it's realistic or not.
But every day that goes by is 250.
The 250 accrues. Now, we've been through the lien reduction process before. I will tell you the $361,000 is a huge number. I probably would agree with you that some of that money should be put towards the property. I can't say I'm going to zero out the lien. I'll tell you now, I'm not going to do that. There will be some kind of fine that will be imposed. How you break that down between you and the previous owner, that'll be a matter of negotiation, but there will be a fine that will have to be paid. I understand that. I don't know if it's going to be $86,000 or not. I don't want to say right now, but you do have to understand when you're meeting with the city, you have to understand that there's probably going to have to be some kind of fine imposed.
Why?
Your Honor, I'm
yeah.
a little confused as to why you would be imposing an additional fine. It would just be the accrual of the continued.
I'm not adding.
Okay.
I'm just the $250. I was asked to pause the $250.
Right, okay, I'm sorry, I didn't hear that correctly. And just to be clear, the 86.5 is not currently coming out of your pocket because it's in escrow at the title company.
Where did it come from? It's still money.
Yeah, it's.
Well, you don't have it.
Yeah, but it's
We put it there.
it's
So the 86,000, it's your money that was deposited into escrow as security for the city because
How many kids I can feed with 86,000?
we have to go back though. We have to understand. You have to go back to April of 2022, where the city agreed. The then city attorney agreed to give the new owners 90 days. Whether you were part of that discussion or not, we don't know, because it was just represented to us that an agreement had been reached.
There was also the reduction on 600.
as part
Right,
of
and that was, and because there was, and that's why there was some good faith shown on the part of the city, and then I was willing to reduce the lien at that point. And that was a substantial reduction. It was what, an 80% reduction?
Yes.
Which is
Yep.
something the city would normally object to.
And we appreciate
And, and I don't know if they're gonna, yeah, and I understand the personal aspect of this, but, you know, I'm looking at the business aspect of this as to what I would want if I were the city attorney and the city code enforcement manager, but I also understand your position too. I'm just telling you that as far as you being able to walk out of this, at the end of this process with no fine at all, that's probably not gonna happen. There will be some kind of fine imposed. The amount of that will depend on how you can negotiate.
What we need, we'll make it happen, I'm telling you.
I-
But we're in-
that's
we're in
fine.
good faith.
All right, so,
Completion, not trying to get.
I'm gonna leave it,
That would be beautiful.
so are you back on August 10th with Ms. Ojello?
Well, we'll have representation here.
It's the next
But,
year.
Your Honor, we would like to move on to item B, which is the authorization to foreclose.
All right, let me hear from Ms. Stuprich on that, go ahead.
Is there a,
So under Florida law, basically, if a lien is, a fine is imposed and a lien is recorded, and the lien is of record for more than 3 months, the local government can come to the special magistrate and request authorization to foreclose that lien. The lien that we're looking at, requesting the authorization for was entered on February 16th of 2022. It was recorded on March the 9th of 2022, and is my understanding from staff, and Mr. Dwar, you'll testify to this, that the lien has not been paid, and that it currently has accrued for 1,441 days. And let me let Pete go ahead and testify, so I don't want to testify to that.
Yes, Mr. Special Magistrate, the fines have accrued for the last 1,441 days and continuing to accrue at $250 per day, and it's now upwards of $361,304, plus an administrative fine of $1,054, and which brings it to the total of $361,304.
Okay. So the request is for me to enter that order. That statute allows me to enter if the lien is not paid. I think this gets back to our original conversation. If there's going to be an agreement, then I'll defer, if there's going to be a meeting to try to resolve this, I'll defer a decision on that too, and give the 4 people here today on behalf of the defendants an opportunity to meet with the city and discuss it. And if there's no agreement reached, I will enter an order that would authorize the foreclosure of the lien.
Sir, how do I know that I can actually action meeting the city? They seem like they want the money. It doesn't look like, I don't feel like they're.
Yeah, I think you're going to have to meet with them, though. I mean,
I would love to.
I mean, having a conversation at a special magistrate hearing or code enforcement hearing, we're not going to resolve that matter today, because I'm not the one that gets into the details
So we
of.
have to request a meeting, and in their mercy, we might have one.
that's what we ask for a
That's what
third
you're
party,
saying?
you know?
I think they understand that they have an obligation to meet with you now as a result of today's exchange. And if that meeting is productive and you come up with an agreement, I'll enter an order that there's an agreement that's been reached, and I'll honor that agreement. If not, then most likely I will enter an order authorizing the foreclosure of the lien, because that's what the state statute authorizes me to do. If the lien is still outstanding, the validity of the lien has not been challenged, even though I know you don't agree with it, but it's still a valid lien because went through a process. Yeah, went through a process, lien was recorded, you bought it subject to the lien, that was part of the negotiations, and now we're at that point where the city has to force the action, and that's what they're doing.
Okay, so in this forum, we will tell you I'm here until, I can meet until noon tomorrow, or any time that you guys set for it. Is
Well, I kind of did ask why you have not called in inspections, and I don't think I got an answer. And by the way, the last inspection was October of 2025. So there is some responsibility on the owner's behalf to call in inspections. It's not just based on them blaming the city for certain things and blaming staff. When they have a responsibility to call inspections in, as we just heard from Ms. Boland, there was a partial passing of an inspection. So again, this idea of meeting with us to discuss calling in inspections or having inspections done, I'm not sure how it is going to. So what would be the reason, please?
Well, I would look at it. Not, hold on, hold on.
All right, let's, one person at a time. Mr. Pavic, go ahead.
I'm not looking at this as two different projects. It's more one project in my mind, and how we're project managing and sourcing guys. And so we basically, you know, went and we started on 550. We moved everything to 600 because there was more of a pressing. There was financial issues, lender, you know what I mean, all of that kind of comes along with it. We were able to quickly get that project resolved. As I said, we're just waiting on Duke. We've been ready for building final inspection for 2 weeks over there, just waiting for Duke to rerun their wire so we can energize and get everything closed off. And then we were kind of circling back. So it wasn't a matter of like walking away or abandoning the job. It was more looking at both of them as one project as a whole and adjusting, man, as I was telling you, you know, we've lost crews, we've had to move guys around and taking it more as like a 360-degree approach.
Again, yes, he mentioned that to Ms. Boland when she made her presentation, but that inspection was requested in February of 2026. My concern is looking at this status report, the building framing was the last inspection done on this property that was called in, that was passed in October of 2025. My request is, how come no inspections have been called in since 2025? Never mind the one that you mentioned about Duke and the installation of the temporary power, called in February. Again, why is it that the last inspection was in October of 2025?
Because you have to go in sequence. You can't go out of order. We got a partial framing inspection. I had to come in and I had to resubmit a revision in order to get the deck approved, so we can do that in order so I can get the front facade finished in order to get the rest of the framing done. So we have a partial inspection for fire protection is in there. We have the underground that also is ready to be inspected. When, as I kind of said before, we had the county owns all the backflows. They didn't like our backflow. When they came to change the backflow, they moved it across the sidewalk. We had to resubmit drawings into Kelly for fire in order to get that. So it's not a matter of not moving the project along. It's that, you know, I would love to move without any inspections. That would be great. I could have had this thing done in 3 months. But there's a lot of hurdles that we all have to go the right way. And sequencing is a big part of construction. You can't go out of order.
And so where are you in the order?
In the order, like I said, we just got drawings back for the underground. As soon as I get that inspection, I can close up the ground. I can get all the concrete. I can get all that on the inside. We had materials that were stolen. I mean, that was another thing. We had a bunch of materials that were on site that got stolen. I can provide police reports for that. We had to repurchase that, and all the while, you know, we've been working behind the gun as far as making sure that we've been able to keep because everything costs money for us to keep on doing things. So, I mean, we have the plumber I think he's on site now. Like, that's our next one, is to get our plumbing rough-in completed. We reordered the electrical materials that were stolen. I don't know, when were they stolen? Kiefer, do you remember the date?
April.
In April. So.
May 2025, we had like a lot of substantial.
I mean, and there was just a lot of homeless people all running through here.
We have a police report and a full.
Yeah. So, I mean, like I said, when it comes to inspections, I was moving this whole thing as one project as a whole.
When you say one project, are you talking 600 and 550?
Yeah, in my
All right,
mind.
well, right now, they're two separate projects.
Fair enough.
And you have to focus on 550, because 600, it sounds like you're going to get your inspection on Friday.
Yes.
And you'll be able to move forward with that, assuming it's all in compliance.
Yeah.
My point is, you need to move quickly. You need to get it done.
I agree.
You can meet with the city, ask for whatever inspections you need now, provide whatever proof of funds they may be asking for, so they can make sure that you have the wherewithal to finish the project. and whether they agree to 3 months, 4 months, 6 months, that's something. And if they don't agree, then at that point it comes back to me, and then I'll make a decision. I'm not at that stage in this process for a lien reduction. So, it is accruing at $250 a day. I've told you I'm already willing to consider a lien reduction, but obviously I need to see a finished product, because as Ms. Stuppert said earlier, and Mr. Dewar confirmed, the lien reduction comes after compliance has been achieved.
Maybe your owner can tell us what he needs, and we will supply it, we will deliver. If you, sir, can tell us, hey, I need to see from you 1, 2, 3, 4, our obligation is to show it to you as a third party, if you want.
Yeah, I'm not going to. Yeah, I'm not going to mediate. I get that. I'm not a construction guy, and again, I know Mr. Pavic indicated there's sequencing that has to happen, and I don't have that expertise to start trying to map out how this building gets finished. I don't have that.
I have.
Nor is it my role to do that. It's a question as to whether you want to meet with the city, and if you do,
We do want to meet. Do they want to meet?
If the city wants to meet with you,
Yeah.
if they tell you no, that they're not going to meet,
will
and they're
be-
going to go through formal process, that's fine too.
Why
And then
wouldn't
we'll
they?
go back.
Want the city, want the building to be finished? I mean, it doesn't make any sense. I've dealt with I don't know how many municipalities in America. This is not the only state we live in.
Yeah,
I mean, this is the worst I've seen. I can't believe I'm even defending the case. But I have a question to you, sir. 600 Corey, built from scratch up. How long it took? Is that a proof to you that we can finish, or is that talk?
I'm not the person to ask that question.
Why?
Yeah,
You're
so
saying I can't
let's,
finish
Not
like-
as-
all right, let's try to
600
focus.
600 even.
Yeah, Mr.
I have
Diane.
the proof.
600 is not part of this.
All right,
discussion.
so
No, but I'm
we're
saying
gonna,
it
I'm gonna
shows you
wrap
we
up,
have the
I'm gonna
ability
wrap
to
up I'm gonna wrap up the hearing now.
Okay.
And because I sense that we're going the wrong direction at this point. And I think at this point, you need to make a decision as to your next step. You've made an offer to meet with the city. Mr. Dewar will get back to you, or someone from his staff will get back to you. I'll take everything under advisement. The city's request to authorize the foreclosure of the lien, and also the order directing the title company to release the $86,500. We'll reconvene. Is it August 10th, and is your next hearing date?
It
Yes,
is,
sir.
but Your Honor, this is a unique case. If there's a date that is more agreeable, it's just one case, basically, that is before you.
Would you be back on?
I will
this-
make
you'll
myself
continue?
available,
Is there a
yes.
date, middle of August, and I know we've got Mr. Kestenbaum from Virginia, and Mr. Abraham, and Mr.
I live in Virginia, like 10 miles outside.
Yeah.
We are in Wisconsin.
And you're in Wisconsin, right?
And I know that in August, I'm out of the country. So.
Me too, by the way, guys.
August, you're out?
Yeah, we're too out of country, so if you.
I'll be back on the third week in August, available. I have 2 weeks period that I'm not around, 2.5. I'm happy to come here before or after.
We could leave it the 10th then. I mean,
No, I
that,
think he said he's out,
I'm
so,
not gonna be here on the 10th.
Same. And to show you
And
that we're.
he's gonna be gone for a while.
And, to show
August
that we are-
24th?
To show that we were to fly international to come here, that's, we show you that we want to finish.
we would like you to finish too. We'd like this case.
Let's do it.
All right.
We're here, let's work.
but,
Man, let's do it.
You have a
Ms.
lead.
Stuppert, your schedule?
Your Honor, what date would you like?
You tell me what your,
The first week of August is pretty bad for me. The second week being the week of the 10th, I do have flexibility towards the end of the week. The third week, I have more flexibility.
all right. And will one of the owners be available on the third week of August? That'd be August 17th through the 21st. It would have to be,
To say it, but I gotta check with the wife. If she's not traveling,
Okay.
I know it's kind of funny, but.
Ms. Stuppert, how about the 24th? Monday, the 24th?
No, I cannot.
Cannot.
We give you a date.
Your Honor, we have other attorneys. I mean, I can send
Or I
someone
could
else.
do Friday, the 21st,
No, not Friday.
not Friday.
Well,
There's no one
I-
here on Friday.
okay.
You want someone else to handle this?
Like a month from today, yeah?
Whatever works. We would like this thing to move forward, one way or another.
Yeah, a month from today would be August 10th.
Okay,
And
I can't. I would be happy to come here.
The
sir.
17th?
A week later?
I can't. I'm not gonna be here.
Yeah, the 17th, I'm available.
There's a planning board meeting in here On the 17th.
What time?
That's at 4 o'clock.
What date is the 17th, ma'am, please?
It's
It's a Monday.
Monday the 17th.
Monday at
August
10?
Let me try and,
Monday at 10?
August 10th
No, Monday, August 17th
at 10?
10 a.m.
Yeah, I mean, is it possible to do hearings via video
Zoom?
conference?
No.
You don't do that?
oh, it has to be physical presence? I can advise on my availability, and Omer sure is not going to be here. I can advise on my availability as soon as tomorrow.
Your Honor,
Just
we
have to
can
make-
spend another hour on this.
Yeah, let's schedule
Pick a
some.
date.
We want to waste the time.
And I think we're all
Mr. Joe, you
adults.
said Fridays are not available at all?
We don't have staff here. We don't have building staff and
Correct.
finance.
Got it.
Do you want to give us your opinion and we'll figure out in August, ma'am?
I can tell you for a fact that the week after that I can for sure. I think my wife is just gone on that
Do
week.
we do August 24th? I
That
think.
will work for sure for me.
I'm not available, but I can send some.
Somebody from your office? All right. And
10 a.m., August
morning or
24th.
afternoon? You want to do afternoon? 10 a.m.?
Although, what about the 25th?
Also work. That week.
25th is fine.
I can be
10
here,
a.m.
the 25th.
I can,
25th definitely work for me.
all right. August 25, 10 a.m.
Okay.
Thank you.
Thank you.
Thank you.
All right. We'll close the hearing for now. Continue all matters pending until August 25th at 10 a.m., same room. Thank you.
Very much. Guys, thank you. Hopefully we can make it happen. Thank you so much for your time.